That scene in pretty much every legal drama ever made. The music swells, the gavel bangs, the losing lawyer storms out onto the courthouse steps surrounded by reporters and shouts, "We are taking this all the way to the Supreme Court."
Yeah, it is a classic trope. It's the Hollywood version of how justice works, really. It implies that the Supreme Court is where the real action happens, where the final battle is fought.
Right. It's the main event. But today, we're going to completely debunk that idea for you. We've been digging through a massive stack of sources for this deep dive into the Wikipedia entry for the Court of Appeal of England and Wales. We're looking at judicial statistics, historical records of the English legal system, the procedural rules.
All the dry stuff that actually
Yeah,
governs the courts, yeah.
exactly. And the reality is just quite different from the movies. The Supreme Court is, it's kind of the show pony.
Well, that might be a little harsh, but statistically you aren't wrong. I mean, the Supreme Court in the UK hears maybe 60 to 80 cases a year. That's it. It deals with the high concept, constitutional philosophy type of stuff.
Whereas the court we are diving into today, the Court of Appeal, is the real engine room.
Mm-hmm.
This is where the heavy lifting happens. If the Supreme Court is the philosophy department, the Court of Appeal is the emergency room.
That's a great way to put it.
It's where the messy, high-volume, high-stakes work of actually, correcting the law takes place day in and day out.
Exactly. This is the second most senior court in England and Wales, and frankly, it's the place that keeps the whole machine running. So today, our mission for this deep dive is to unpack the Court of Appeal. We're going to look at how it actually functions, why it was created to fix a system that can only be described as, a total dumpster fire.
The complete mess, yeah.
And how it decides whether a legal fight ends right there or goes all the way to the top.
And before we get into the nitty-gritty, we really need to set the stage visually for you, because we aren't talking about some modern glass office block here. We are talking about the Royal Courts of Justice on the Strand in London.
Oh, it is an incredible visual, just massive, imposing Gothic revival architecture. You've got stone corridors, vaulted ceilings, stained glass. It looks like a cathedral, or maybe Hogwarts for lawyers.
I love that image.
Yeah.
But that architecture actually tells us something about the history, doesn't it? Because before that building opened in the 1880s, the English legal system was, messy, puts it really lightly.
Yeah, messy is generous. If you go back to the mid-19th century, so before 1875, there wasn't really a court system. There were 12 different superior courts.
Whoa.
12. And the problem wasn't just the sheer number, it was that they didn't really talk to each other.
So if I had a legal problem back then, how did I even know where to go?
That was the issue. It was a complete labyrinth. Let's say you had a dispute. If it was a common law issue and you wanted to appeal, you had to go to something called the Court of Exchequer Chamber.
Which sounds incredibly medieval.
It was. But if your dispute was about a trust or an estate, which falls under equity law, you couldn't go there. You had to go to the Court of Appeal and Chancery. And if it was a maritime issue or something ecclesiastical, you went to the Privy Council. You could literally spend years and a small fortune just figuring out which door to knock on.
So the system was basically inefficient by design.
Inefficient by accident of history, really. It had just grown organically over centuries without a master plan. By the 1870s, with the Industrial Revolution booming, commerce just couldn't function with a legal system that's slow and confusing. They desperately needed a hard reset.
Enter the Big Bang of English law.
The Judicature Acts of 1873 and 1875. This is the moment modern English law really begins. They took those 12 fractured courts, smashed them together, and created one single Supreme Court of Judicature.
Just to clarify for the listener, because the names get confusing here, this isn't the Supreme Court we have today, right?
Correct. That is a modern branding issue. In 1875, the Supreme Court of Judicature meant the combination of the High Court, where the trials happen, and the Court of Appeal, where the corrections happen. They streamlined everything into one structure.
Order from chaos. But looking at the sources we gathered, there's a glaring omission in this new system. It seems like the Victorians cared a lot about money and property, but not so much about people.
Ah, you noticed that. When the Court of Appeal was first set up, it was almost exclusively for civil cases.
So if I lost a contract dispute, I had a shiny new court to go to. But if I was wrongly convicted of a crime,
You were largely out of luck. There was no formal, robust avenue for criminal appeals until the establishment of the Court of Criminal Appeal in 1907. Before that, the system effectively assumed that a jury verdict was sacred and infallible.
That is wild.
It is. It actually took some pretty horrific, high-profile miscarriages of justice to force the government to admit that, actually, juries and judges make mistakes in criminal trials, too.
It really tells you where the priorities were at the time. Property first, liberty second. Exactly.
Okay, so eventually they fixed the structure. We have the High Court, the Court of Appeal, and the House of Lords, which is now the Supreme Court. But that sounds like a very long ladder to climb. And the notes mention a shortcut called leapfrogging.
Yes, leapfrogging sounds like a playground game, but it's a crucial tool for efficiency. It was introduced by the Administration of Justice Act, 1969.
How does it work?
Well, normally you have to go step by step. High Court, then Court of Appeal, then Supreme Court. But sometimes a case comes along where everyone knows the Court of Appeal literally cannot help.
Why couldn't they help?
Because of precedent. Let's say there is an old House of Lords ruling that is clearly outdated, but it's still technically the law. The Court of Appeal must follow it. They cannot overrule their bosses. So there's no point in having a hearing just for the Court of Appeal to shrug and say, we agree with you, but our hands are tied.
So leapfrogging lets you skip the middleman. Exactly. You jump straight from the High Court to the Supreme Court. It saves months of time and tens of thousands of pounds in legal fees. It's the system admitting, okay, we know where this is going to end up, let's just get there. There was also a reform back in 1934 that stopped county court cases from having to go to the High Court first, sending them straight to the Court of Appeal.
It's all about speed and saving money.
Efficiency is the holy grail of the modern judiciary.
Let's look at how the court is organized today, because even though they are all in that same Gothic building, we are really talking about two very different worlds operating side by side.
We are. Since 1966, the court has been formally split into two divisions, the civil division and the criminal division. And culturally, they are quite distinct.
Let's start with the civil side. Who is running the show there?
The civil division is led by the Master of the Rolls.
Which has to be the best title in the British government. Sounds like a character from Dungeons and Dragons.
It sounds medieval because it is. It goes back centuries. Currently, that role is held by Sir Geoffrey Voss. The Master of the Rolls is effectively the CEO of civil justice. They hear appeals from the High Court, the county courts, and the family court.
And the sources suggest that this person, the Master of the Rolls, often has more influence on the daily life of the law than even the heads of the Supreme Court. Why is that?
It comes down to volume and scope. The Supreme Court deals with high-level constitutional points that might only affect a few people directly, but the civil division deals with everything else: contract disputes, negligence, family breakdowns, intellectual property. The Master of the Rolls sets the tone for how business is done in the country.
I suppose the classic example is Lord Denning.
You can't talk about the Court of Appeal without mentioning Lord Denning. He was Master of the Rolls from 1962 to 1982. He treated the Court of Appeal like his personal instrument for modernizing the law. He famously cared more about justice in the moral sense than strict adherence to the rulebook.
He was the rebel of the judiciary.
A massive rebel. He often clashed with the House of Lords. But because he sat in the civil division for 20 years, he shaped the law of contract and tort more than any other single judge in the 20th century.
Now let's flip the coin to the criminal division.
This is led by the Lady Chief Justice, currently Baroness Carr of Walton-on-the-Hill. This division hears appeals from the Crown Court. So we are talking about trials on indictment, jury trials, serious crime.
And this is where the rules of the game change. I found this fascinating when looking at our deep dive materials. The notes mention that the criminal division is less bound by its own past than the civil division.
This is a critical distinction. In the civil division, they operate under strict precedent. They generally must follow their own previous decisions. Why? Certainty. Businesses need to know that a contract clause means the same thing today as it did in 1990.
But in criminal law?
In criminal law, the currency isn't money, it's liberty. If the Court of Appeal Criminal Division realizes that a previous decision was wrong, and following it would mean keeping a person in prison unjustly, they have more flexibility to say, we got that wrong, and depart from it.
That makes total sense. Sorry we locked you up, but we really like consistency isn't exactly a great motto for a justice system.
Precisely. The liberty of the subject trumps the need for legal neatness.
Okay, so that's the structure.
Yeah.
Now I want to talk about the user experience. Because I think there is a misconception, again, fueled by TV, that everyone has a right to appeal. That if I lose a case, I can automatically demand a second opinion.
That is the single biggest myth. In the modern English system, you have almost no automatic right to appeal.
So I can't just fill out a form.
You can fill out the form, but the door is locked. You need permission or leave to appeal. And the bouncers at the door are incredibly strict.
This wasn't always the case, though, was it?
No. Until the late 90s, it was much easier. But the system was drowning in paperwork. Lord Woolf and Sir Geoffrey Bowman conducted these massive reviews of the justice system. Bowman found that in nearly 70% of cases, there was a 14-month delay just to get a hearing. Some cases took 5 years.
That's justice denied by delay.
Exactly. So they installed the filter. Now, to get permission, you have to prove one of two things. Either your appeal has a real prospect of success, meaning it's not just a Hail Mary pass, or there is some other compelling reason for it to be heard.
Compelling reason sounds a bit vague.
It usually means a point of public interest. Even if you might not win, the law needs clarifying for everyone else. But if you can't prove that, you don't even get in the room.
And what if I'm really stubborn? Say I lost in the county court, I appealed to the high court, I lost again, and now I want to go to the Court of Appeal.
That is a second appeal, and the wall there is 10 feet higher.
They really don't want to see you at that point.
They really don't. The leading case here is Tanfern Ltd v. Cameron MacDonald. The court was very blunt. They said that Lord Justices constitute a scarce resource. You don't get a second appeal just because you think the High Court judge was wrong. You only get it if the case raises an important point of principle or practice.
So at that stage, it's not about you or your grievance anymore. It's about the law itself.
Correct. The system values finality. At some point, the argument has to end so everyone can move on.
There's another distinction here that I think trips people up. Review versus rehearing. I always assumed an appeal was a do-over. Call the witnesses back, try again to convince a new judge.
A very common mistake. The Court of Appeal almost never hears live evidence. They don't want to see the witnesses.
Why not? Wouldn't seeing the witness help?
Their logic is that the trial judge was the one who looked the witness in the eye, saw them sweat, and decided if they were lying. The Court of Appeal respects that first-hand advantage. So an appeal is a review. They are looking at the transcript and the legal arguments to see if the judge made a technical error in the law or a massive procedural blunder.
So they are grading the judge's homework, not retaking the test.
That is the perfect analogy. Unless the judge's decision was plainly wrong or perverse, meaning no reasonable judge could have reached it, they won't interfere.
Speaking of grading homework, let's talk about how the actual process has changed. Because reading about the old days is hilarious. Is it true that lawyers used to read everything out loud?
It sounds like a joke, but yes. Before the modern reforms, oral advocacy was taken literally. Counsel would stand there and read the entire judgment of the lower court, the witness statements, the documents, the correspondence.
That could take days.
Weeks in complex cases. It was an endurance sport, and the judges would just sit there and listen.
Why? Why not just read the papers beforehand like a normal person?
Tradition. And a bit of arrogance, to be honest. In the 1960s, when people suggested moving to the American system, where judges read briefs before the hearing, British judges turned their noses up at it. They felt that justice must be seen to be done, which apparently meant heard to be done.
We don't do that here.
Exactly. But eventually, the logic of efficiency won out. The volume of cases made the old way impossible. Now we have skeleton arguments, written summaries, and judges do pre-reading. They come into court already knowing the facts.
It saves a massive amount of time.
It does, but it also changes the skill set. A lawyer can't just be a good orator anymore. They have to be a brilliant writer.
And the modernization isn't just about reading. We have technology now. Cameras in the court.
We do. Since 2013, the ban was lifted. But notice the caution. If you watch the live stream, it's on a 70-second delay.
The oops buffer.
Exactly. In case someone blurts out a name that is supposed to be anonymous or sensitive security information comes up, it's transparency, but with a safety net.
I also saw that they're pushing mediation heavily, the Court of Appeal mediation scheme, which feels very modern.
This is fascinating. If you have a contract or personal injury claim under £100,000, you might get diverted to mediation. The 2022 data showed a 40 to 50% success rate.
That's huge. That's half the docket cleared without a judge lifting a finger.
And going back to the scarce resource argument, that is vital. Every case settled in a side room is a slot opened up for a major constitutional appeal that really needs judicial attention.
Let's talk about the people making these decisions. Who makes the cut?
There are currently 39 Lord and Lady Justices of Appeal, with a mandatory retirement age of 75.
And the pay isn't terrible.
It's comfortable. A Lord or Lady Justice makes about £188,900 a year. The Lady Chief Justice is on over $230,000. But consider what these people could earn in private practice as top KCs. They are taking a significant pay cut to sit on the bench.
True. It's public service. And I want to touch on the diversity aspect, specifically the titles. Because English law loves its traditions, even when they stop making sense.
The language lags behind the reality. For a long time, the statute said the judges were Lord Justices of Appeal. Even when the first woman, Dame Elizabeth Butler Sloss, was appointed in 1988.
So she was officially a Lord Justice.
Officially, yes. It wasn't until 1994 that the practice shifted to calling them Lady Justice informally, and it took until 2003 for that to become the formal statutory title.
2003 is surprisingly recent.
It is, and the numbers are shifting slowly. As of early 2026, we have 10 Lady Justices out of the 39, so we are at about 25%. It's better than it was, but it's not parity yet.
Before we wrap up, we have to tackle the big technical beast. We threw around the Latin term stare decisis earlier. I want to understand, strictly speaking, can the Court of Appeal change its mind?
This is the question that keeps law students awake at night. The short answer is, generally, no. They are bound by their own past decisions.
Why tie their own hands?
Certainty. If the law changes every time a new judge sits on the bench, nobody knows how to behave. But they realized this could lead to ridiculous situations where they are forced to follow a bad law. So in 1946, in a famous case called Young v. Bristol Aeroplane Co. Ltd., they set out the escape hatch.
The exceptions.
Right. There are three main ways the court can ignore its own previous ruling. First, if the previous decision was made per incurium.
Which means
It's Latin for through lack of care. Basically, the previous court missed a relevant statute or a binding House of Lords decision. They made a mistake because they didn't see the whole picture.
So, oops, we goofed.
Exactly. Second exception, if there are two previous Court of Appeal decisions that conflict with each other.
Which happens.
It happens more than you'd think in a system this big with so many cases. In that case, the current court has to act as a tiebreaker and pick one to follow.
And the third.
If the Supreme Court or the old House of Lords makes a ruling that effectively overrules the Court of Appeal, the boss's word is final.
It seems like a delicate balance. You want the law to be predictable, but you don't want it to be stupid.
That is the eternal tension of the common law. Young v. Bristol Aeroplane is the attempt to balance that rigidity with just enough flexibility to not be absurd.
So, pulling this all together, we've gone from a chaotic mess of 12 courts to this highly structured, filtered, efficient engine room. What is the big takeaway here?
I think the trajectory is clear. The story of the Court of Appeal is the story of professionalization. We moved from a system that was romantic but dysfunctional, with the oral readings and confusing jurisdictions, to a system that is ruthless about efficiency. The permission filters, the pre-reading, the mediation schemes, they are all designed to manage the overwhelming demand for justice.
But there's a cost to that efficiency.
There is, and that's the tension we should reflect on. The Court of Appeal exists to correct errors, to ensure justice is done. But every time we tighten the permission to appeal filter, we are effectively saying that finality is more important than absolute perfection.
It's a pragmatic compromise. We want to get it right, but we also just need to get it done.
Exactly. If we allowed every grievance to be litigated forever, the system would collapse. The filter is the price we pay to keep the machine running.
And that leads to a provocative thought for everyone listening. We tend to think of justice as this pure, absolute search for truth. But looking at the Court of Appeal, it looks a lot more like resource management. As we push for more mediation and stricter filters to save money and time, are we approaching a point where good enough justice is becoming the standard? Are you comfortable with a system that might leave a few stones unturned just to keep the conveyor belt moving?
It's the question every modern legal system has to answer. How much justice can we afford?
Something for you to chew on. That's it for this deep dive into the engine room of English law. Thanks for listening.
A pleasure.
See you on the next one.